In this module, I'm going to spend some time discussing religion in the schools and several pieces of case law, both from the U.S. Constitution and various cases that have come about as a result of challenges to schools on the basis of the First Amendment, which includes religion and or prayers in school. The first piece from the U.S. Constitution is commonly known as the Establishment Clause of the First Amendment. It is the first of several pronouncements in the First Amendment stating that Congress shall make no law respecting an establishment of religion together with the Free Exercise Clause or prohibiting the free exercise thereof. These two clauses make up what are called the religion clauses of the First Amendment. The religion clause has generally been interpreted to prohibit, 1, the establishment of natural religion by Congress, 2, the preference of the U.S. government of one religion over another of the case, and the year that the U.S. Supreme Court provided its findings on the case. You will also note that this is the first Supreme Court case that incorporated the Establishment Clause of the First Amendment as binding upon the states through the Due Process Clause of the 14th Amendment, which we will speak about during the course of our discussion on religion in the schools. The decision in Everson marked the turning point in the interpretation and application of the disestablishment law in the modern era. We'll go on to discuss the Equal Access Act, or Limited Open Forum. This act provided that if the schools receive any federal aid and has a limited open forum, that is, a student-led non-curricular club that meets outside of class time, it must allow additional such clubs to be organized and must give them equal access to meeting spaces and school publications. There have been many challenges to this. When Edward Shemp, a Unitarian Universalist, filed suit against the school district in the U.S. District Court to prohibit the enforcement of a Pennsylvania state law that required his children, specifically Ellery, to hear and sometimes read portions of the Bible as part of their public school education. The law required that it be read without comment at the opening of every school day in every public school. The contention was that the statute violated his and his family's rights under the First and 14th Amendment. Pennsylvania law had a statute that compelled school districts to perform Bible readings in the morning before class. 25 states, in fact, had the same laws, allowing quote-unquote optional Bible readings, with the remainder having no laws. More famous than the Shemp case was the mother of the plaintiff, 13-year-old Bill Murray. Madeline Murray O'Hare, who founded the group Americans Atheists in 1963, added to this case, and together the two cases were consolidated on appeal to the U.S. Supreme Court. It declared in its findings on an 8-1 vote that school-sponsored Bible readings in the United States in public schools were unconstitutional. Abington continued the trend with regard to the Establishment of Religion Clause of the First Amendment, specifically built upon Supreme Court precedents, as noted. The next case noted is Wallace v. Jaffrey, 1985. It was a case in front of the U.S. Supreme Court looking at the issue of silent school prayer. An Alabama law minute at the start of each day for a moment of silent meditation or voluntary prayer. Sometimes the teacher of the classroom asked the student to recite some prayers. Well, the U.S. District Court allowed the practice and found in favor of the defendants. The U.S. Court of Appeals reversed it, holding the law unconstitutional, and the Supreme Court also indicated that the Alabama law violated constitutional principle. You might want to think about what were the reasons for these decisions in terms of the separation of church and state. Practice to the school board. Their point was that only a specific version, in this case a Douay version of the Bible, was the only correct translation for their children. They were unable to convince the school board, and then they took it to circuit court, and that the circuit court decided the readings were non-sectarian because both the translations were of the same work. At this point, the parents then took their case to the Wisconsin Supreme Court. The Wisconsin Supreme Court looked at this case and overruled the circuit court's decision, concluding that it illegally united the functions of church and state. In 1963, the U.S. Supreme Court then banned government-sponsored compulsory prayer from public schools, citing this case, the Edgerton Bible case, in their decision. The next case, a case in 2000, Santa Fe Independent School District versus Doe, was heard before the United States Supreme Court. It ruled that a policy permitting student-led, student-initiated prayer at football games violated the Establishment Clause, and the court found this policy unconstitutional. Lee versus Wiseman in 1992 was a major decision, as it was decided by the Rehnquist Court, the court that was appointed by President Nixon, and involved prayers, or the Chief Justice appointed by President Nixon. It involved prayers led by religious authority figures at public school graduations. The court followed a broad interpretation that had been a standard and reaffirmed the principles of such landmark cases, which basically indicated that that practice could not continue. And it led to the Newdow versus U.S. Congress, Elk Grove United School District in 2004, which led to a 2002 ruling of the U.S. Court of Appeals in the Ninth Circuit that the words "under God" and the Pledge of Allegiance are an endorsement of religion. The case was heard by the U.S. Supreme Court and found that the 1954 insertion of "under God" was made to recognize the supreme being and advance religion at a time when government was publicly intervening against an atheistic communism, a fact which, according to the court, the federal government did not dispute. President Dwight David Eisenhower signed the act, which added the phrase "under God." He also announced from this day forward the millions of our school children would daily proclaim in every city and town, every village and rural schoolhouse, the dedication of our nation and our people to the Almighty. The Rehnquist opinion asserts that the term does not endorse or establish religion, but actually asserts that the term merely acknowledges the nation's religious heritage, which was the majority opinion. These will give you some case foundation for the separation of church and state, the role of the U.S. Supreme Court and the Congress in determining such rules that apply to all schools in the United States of a public nature. Of course, religious schools do fall outside of these rulings, and parents send their children to the religious schools so they can be afforded the addition of a religious education and perhaps a general secular education.